Hi there. Welcome to UMan IP. I'm Justin McNaughton and Sharon Urias is with me. We do this show about once a month and we just pick different topics related to intellectual property. And I am a prosecutor, meaning that I register and protect trademarks. And Sharon is a litigator, meaning that she fights about them and defends people when they get into disputes over trademarks. So today is a topic that I actually did not think we would be doing. And it's all about cyber squatting again. So this is something that I did years and years and years ago, lots of these cyber squatting cases. And then it sort of went away as Google's algorithms improved. And now all of a sudden it's back again, which is kind of astounding. And it seems to be a result of all of these new generic top level domains. And so where it used to be that people did cutesy little things and try to redirect traffic, now they're registering domains that end with .shop or .club or .vip or .xyz. And I don't know, Sharon, do you have some other ones there?
Yeah, I mean, I haven't seen these pop up yet, but there are so many new TLDs like .doctor, .law, .farm, my favorite, .yoga. It's very interesting.
So, and it, and I wouldn't have I mean, I had heard talk about this causing more, an increased level of infringement and cyber squatting and that sort of thing. I guess I didn't think it would actually be a thing, but we're starting to see it a lot. And so here we are.
Yes, that's right.
So I guess, do you want to just, dust people off to back when, back the
The
days
late
when they
90s,
got dressed in meat,
early
that sort of
2000s.
thing.
Yeah. Yeah. So what is cyber squatting? It's when someone who's not the owner of a trademark registers that trademark as part of a domain name and then tries to profit from it. In the old days, you might have somebody register coca-cola.com or something that was similar to coca-cola.com and try to profit from that. So the cyber squatters either use the domain name to try to divert traffic from the trademark owner or otherwise trade on that trademark owner's brand, or they actually try to ransom it back to the trademark owner. And we're actually even seeing that today, where someone registers a domain for a trademark that they don't have any rights to. And then instead of going through, the auction process with GoDaddy or whoever the registrar is, they actually try to sell it back to the domain owner for an exorbitant fee. So
To the trademark owner.
That's what I meant, to the trademark owner. And the conduct violates federal trademark law, which specifically is the Anti-Cyber Squatting Consumer Protection Act. It's kind of a mouthful. It was enacted back in 1999. And it really, it's been around for a while. There's a lot of cases on it. And now we're seeing it, as Justin said, kind of dusted off again.
So there are a couple different ways that we see it, that it pops up. The oldest way, back in the 10, 15 years ago, it was always things like somebody doing a misspelling of a URL, and they would omit a vowel, and then all of a sudden, people who couldn't spell well would end up at the wrong website or something. And eventually Google and the other search engines figured this out and basically eliminated that as a problem. So then even if you mistyped it, Google would still figure out what you were trying to find.
And they call that typo squatting, right?
Yeah, and that was typo squatting, and that really required a technical fix, or we'd still be dealing with that, because I'm pretty sure that everyone still misspells everything. So that went away, but there were a lot of those 10, 15 years ago. And then it kind of died down a little bit. And then recently, with all of these new, where you can have any generic top level domain that you can basically, people can go and set these up and then sell them to other people. And so then people come along and register an existing trademark .shop or existing trademark .xyz. And then it's spelled exactly right. Like the trademark is exactly spelled right usually, and it has a different ending on it. And apparently this is causing confusion, and apparently the search engine algorithms haven't quite been able to deal with this yet.
I don't know how they could.
What's that?
I don't even know. I mean, not that I'm a technical person who deals with that, but I don't know how they could address that issue.
I mean, it seems, I think that they are, and they will, but it still gets through sometimes right now. So you'll have, and it's also a little bit strange because the way that we're seeing it mostly now is that somebody will register like .shop, and then they will copy the actual domain owner's own website. And then apparently they're using this for phishing, or they're using it to basically to trick people into giving, some person in whatever country, wherever, their personal and financial information. And so the websites look identical. I mean, they've copied everything except that you're not actually going to get something when you order. And so that's why these are a little more dangerous than some of the original ones, where, in the old days, it was actually a competitor who would take the domain and then reroute things. And all of a sudden you're like, whoa, how did I get over to this other, competitor website? And they were just forwarding it. But now they leave it on that same website. They really are trying to steal information sometimes. And then another way that it comes up is if for like a celebrity or for a company where somebody will go and register this new domain name and then again try to sell it back, or try to actually just hijack it and pretend that they are the celebrity, or pretend that they are the company, to create confusion. But it can be pretty damaging. When this is a pretty, the process for dealing with it is pretty boring process. But usually when this happens to you, it's very stressful because it doesn't make sense.
Right.
It makes no sense at all as to what the people are doing. And you often can't tell who it is, and you often can't tell exactly what they're doing, but
Or
that
why they're doing it.
Right.
Sometimes that's not even clear. So I think to stop cyber squatting, you really have to understand how the domain name system works. And most people don't. Most people know how to use the internet. They may not be able to spell, but they can, go to a website. But basically, the domain name system is administered by an international organization that's called ICANN, ICANN, and that stands for the Internet Corporation of Assigned Names and Numbers. Kind of a mouthful. And ICANN has enacted policy to deal with domain name disputes. We abbreviate it, call it the UDRP, which stands for the Uniform Domain Name Resolution Dispute Policy. Yeah, I think I got that right, UDRP. And basically, the UDRP sets forth, and you can find this if you go to icann.org. It sets forth the manner in which you can resolve a domain dispute. It's effective, it's inexpensive, at least compared to the court system. And you don't even have to know who the cyber squatter is, because if you have ever looked up domain name information, you can go to whois.sc.org. And you can actually type in the name of any domain on the internet, and it will give you information about it: the registration date, the expiration date, the creation date, tells you who the registrar is. It may or may not tell you who the registrant is, because if you have ever registered a domain name, you'll know that they always ask for a lot of add-ons. Do you want to buy .biz, .shop? Do you want to add privacy protection for, whatever it is, $19 a year? And so it's inexpensive and it's easy to protect your personal information if you don't want everyone in the world, literally, to know that you own a specific domain name. But so then the question is, well, if I don't know who the registrant is, how can I go after them? And the answer is the UDRP has solved that issue. You file your complaint against this anonymous owner, and the governing body knows who the registrars, who the registrants are. And it only takes a few months to get a resolution. You file your complaint. The other side has to respond. I think it's within 20 days. Then it's assigned to an arbitrator, and the decision is made on the papers. So that is way more efficient and way faster than any court procedure would be.
Yeah, and then if it's transferred, then WIPO actually administers the transfer, and the registrars are required to effect the transfer. So you don't. So and as you start it, the domain gets locked, so the person on the other side can't.
Right, and that's an important point, which is the minute you file your complaint, the bad guy or gal can't suddenly transfer it to a different registrar or transfer it to another person because it's locked and they can't do anything with it until the dispute is resolved. So Justin, you mentioned WIPO, that's the World Intellectual Property Organization.
Yeah, so probably the two main arbitration organizations that handle these would be WIPO, the World Intellectual Property Organization, or NAF, which is the National Arbitration Forum. And it's just a different, their fees are roughly the same. It's just different organizations doing essentially the same thing. But they, you have to prepare the complaint with very specific requirements, and they have to be done in a certain format. And then you submit them, and then you won't know who's assigned or anything about it until you get a decision one day. And then if it's transferred, then you'll see the transfer. You'll get instructions, that sort of thing. So, but since these proceedings, the only thing that can be granted is transfer of the URL. The decision, you file the whole thing. The only thing that can happen is they can either transfer it or they can deny it. There is an opportunity if you settle with the other party in the meantime, you can do that, but it's not as common.
Right, and you can't get money from the arbitration either. Can't get your attorney's fees back.
Money. They don't even have authority to do anything like that. The only thing they can do is transfer the domain. So that's the kind of the bummer part, is that often people are put in a position where they have to do something because somebody is spoofing their site, and they have to get it resolved. And this is the fastest way to do it. But the reality is that for many of these, there's not a good way to, you can't, even if you know who these people are, a lot of times it's very difficult to try to sue them because they're in some remote part of the world.
Although the good news is most registrars have in their terms of use a requirement that if you register your domain with that registrar, so for example, GoDaddy, if you register a domain with GoDaddy, GoDaddy requires that you submit to, I hate to sound too technical, but to jurisdiction in Arizona where GoDaddy is located. Right. So if you know who the domain owner is, you can file a lawsuit against them, even if they're across the world. You can file it in Arizona.
But you still aren't going to get any money. So that's why it's
unlikely.
But the things that you have to do in order to proceed with one of these UDRPs, you've got 5 elements that you've got to prove. The first one, you do have to show that you have trademark rights. And if you have a trademark registration, whether it's in the US or in another country, that can do it. It's not required, but you do have to show that you have trademark rights. And then the second thing is you have to show that, and this is usually pretty easy, but you have to show that the domain that you're fighting over is confusingly similar, that it's a copy, usually that it's a copy, or it's so close that it's identical to what your trademark is. An example of that would be, so Greenspoon Martyr, if somebody were to register greenspoonmartyr.shop, that would be an example. It's identical because the .shop doesn't, it's largely ignored.
Or if they registered greenspoonmartyrlaw.com, that would be confusingly similar.
and the dot law, that generic top level of the name, is just ignored. Then the third thing you have to do is you have to show that the other side does not have legitimate rights. What that means is that sometimes the other side will have an honest to goodness business. And the most famous isn't the right one, but the best example that I have of this is that if you go to Nissan.com, there's a whole history of dispute there, but it's actually, or at least it was last time I checked, owned by some guy who owned like a small computer company. It is not the auto manufacturer. And that's an example where it's just some guy that happened to have the same name, and he had his own business, and he was, I don't think he was really causing anybody any problems. And he has legitimate rights in it, and they're not infringing. And so you can't take that domain from that type of person. Usually that's not what we're running into. Usually it is somebody who is registering it to sell it to you, or is, registering it to interfere with your business, and you can't obtain legitimate rights that way. The second one, I guess it's the fourth one, is that you have to show that they registered it in bad faith. So this one's a little tricky because it means that on the day that they registered it, they had to have been up to no good. And
Right.
So an example of what that isn't is sometimes, for whatever reason, it's pretty common that a company will hire a design firm, and the design firm will register the domain in their own name. Now, it's another topic for another day as to whether that is appropriate and whether you should be using somebody who would do that.
I wouldn't do that.
But what happens in that instance is that if you end up getting in a fight with that web designer later on, this process won't be available to you, because on the day that they registered it, they registered it for you. They had second thoughts later, but that doesn't count. Or if an employee were to register it in their own name, that kind of thing.
That was the one I was going to mention. And that one presents a big problem. So say you have a partner in your business and you say, oh, I'm going to take care of, setting up the web design. You take care of getting the domain registration, and your partner registers the domain in his or her own name. Everything goes great. 10, 15 years later, you guys break up, you're keeping the business, and you say, uh-oh, I need to own the domain because now I have the business. And your former partner says, no, I'll sell it to you, but it's mine. Well, and so you go through the ERP process. Can you get the domain? Did they register it in bad faith? That's the tough element.
Right. Now, that doesn't mean you can't get it back. There are other ways, and there typically it just means that this isn't the right process.
Correct.
But you want to just be very careful so you don't spend a whole bunch of money on the wrong process. Like that might be a situation where if you have that kind of dispute, you probably need to be in litigation anyway. And so you move over there.
And I've seen some decisions go in both directions on that particular topic on the bad faith prong. But as you said, that's a discussion for another day.
So, and then the last one is that you have to show that they are currently using it in bad faith.
Mm-hmm.
This one is not, a lot of times this does get presumed, but I'm not sure that I've ever seen a good example where somebody registered it in bad faith and is not still using it in bad faith. But I guess it is conceivable that could happen. It's not very common, but for context, using it in bad faith can be holding the website out there as a, to sell it. That can be used.
But just parking it is parking it using it in bad faith?
Well, it depends on how they're doing it, but if it's primarily to sell it, or if you can show that, it is primarily so that you can't have it or somehow to interfere with your business, then you can show that it's being used in bad faith. So it doesn't have to be that they are running it. They don't have to start a website that sells the same stuff that you do in order to show bad faith. It's more flexible than that, but you do have to show it. But usually, like we have found that usually when you start investigating these things, there's usually a trail. Like usually the person has done one or two things that all of a sudden you're like, no, they were clearly targeting us. And then these things just fall right into line. When they don't, though, that's where you might look at a different proceeding as well.
Right. And so best case scenario, you show all these elements, you win, and hooray, you get the domain transferred. So it's unfortunately not that simple, not that anything is. If so, let's say you win, or actually let's say you lose. You lose the UDRP, you file it, you think you have everything, you're missing one of these elements. What do you do? Well, you have 10 days to file an appeal with the district court where the registrar is located. So for instance, as 80% of domains are registered with GoDaddy, I do see these here in Arizona, not as many as we used to, but we do see them. And the losing party has an opportunity to file the request. If you lose, you're on the other side of it and your domain is being transferred to the other side of the proceeding. Fortunately, the registrar won't transfer it within that 10-day hold period. So you have time to file your lawsuit. And once you file the lawsuit, you send a copy of that complaint to the registrar, and the registrar, GoDaddy in our example, will not do anything until the lawsuit is completed. The domain will remain locked for the entire lawsuit. And there are different types of these claims. There's reverse domain name hijacking, where you are the trademark owner and the bad guy is able to get transfer of the domain from you to them through the UDRP proceeding. And that's another type of lawsuit that you can file. It's also under the Anti-Cybersquatting Consumer Protection Act. And then you have to go through the court process. And the court is not bound at all by what the arbitrator did. They're looking at it with a fresh set of eyes. And it's essentially a trademark infringement case that includes a cyber squatting claim of some sort. So if you lose in the UDRP proceeding, all hope is not lost, but now you got to go through the regular court system that you were trying to avoid in the first place by filing this, relatively inexpensive arbitration. So,
well, let's so if anybody has any questions, go ahead and submit them in the Q&A. And I mean, Sharon, if you want, let's do some questions. You want me to?
Okay, sure.
Start the questions, and then so one question this is a good question that came up is, does cyber squatting, does it extend over into social media? And so do you want to take that one, Sharon? You want me to?
Sure. So cyber squatting is something specific to, and I'm going to use the word theft sort of broadly, but cyber squatting is something that really only applies to the theft of domain names. When you're talking about social media, and I assume you're talking about somebody using your domain name or your trademark in, Instagram or Facebook or one of the other social media outlets, what you're really talking about is just what we would, call straight up trademark infringement. So if you own, I don't know, Coca-Cola.com, not only are you really, really rich and happy, but if somebody uses, refers to Coca-Cola.com in social media, it depends on how they are using it as to whether it constitutes trademark infringement, but it would not be cyber squatting.
Right, because it wouldn't be a situation where if somebody uses Coca-Cola in their Twitter feed, Coca-Cola is not going to try to take twitter.com from them. Right, to take twitter.com. What
Right.
they're going to do is they're going to send Twitter a takedown notice, which is it's a different type of remedy. It's a different type of process, but they'll send them a takedown notice, and then Twitter will decide whether or not it's going to take down your post or what it's going to do about that. So
right. And if you're trying to direct traffic to Coca-Cola.com, that might even help you. It might be, a fair use under the Trademark Act, but it's not going to be cyber squatting. Cyber squatting, you should look at it as sort of a subset of trademark law. It's a type of trademark infringement.
Right. So here's another one. So what about a case where you are in one country and you have a trademark in that country. So let's say like the United States, and somebody pops up with, a greenspoonmartyr.shop, and then it becomes clear from their website that they're actually in France or in India.
Right. So if it's .shop, then it is subject to the Uniform Domain Name Dispute Resolution Policy. But you have to be careful. You have to look at that. So let's say they registered greenspoonmartyr.au or what's another foreign one? UK or DE. You have to look and see whether those, excuse me, TLDs are subject to the ICANN procedures, and they may or may not be.
Yep. Yeah, and so you look at, and if they are, then that means this process, this UDRP process is available. And then the second part is that you look and see, even though their website might be set up in a foreign country, or it may not have great English, that sort of thing. A lot of times there's some indicia on there as to whether they're targeting the US, right? And so if somebody sets it up as though they're a different company, but they are targeting the US, then you can still use this UDRP process and say, look, this is set up. It may be, it may look like a rough website. It may look like they're in a different country, but they're indeed targeting the US. But it does get a little bit trickier. And that's why a lot of times in these kind of disputes, it becomes pretty clear if somebody is really if they're trying to sell it back to you, or if they are really trying to impersonate you. Those
right.
become obvious.
And so another question.
It becomes tougher though when somebody sets up a new website, they've adopted your name in another country. Sometimes that might not be a UDRP. Sometimes that might be a different kind of claim.
So another question is, so what if someone is actually using the domain name and it's not in bad faith, but they try to sell it to you? Does that create a problem for them? So like if that Nissan guy realizes he can make a lot of money by selling his domain to, gee, I wonder who he would sell it to. Can he have any sort of liability, or would it subject him to transferring the domain?
Yeah, and I don't think so, because you got to hit all 5 of those, right? And it's my understanding that he already won a UDRP process. And so, yeah, if he had a legitimate business, then this process will never work for that. So
right, and even under the ACPA, if he called up Nissan Corporation and said, "I'll sell it to you for $10 million," can they now sue him for cyber squatting under the ACPA?
I don't think so, because he already had rights there. So in that context, two potential companies could want the same domain name, and they could both have trademark rights in it. And in that case, it's just whoever has it, and then you can't just take it because you're the
That's right.
company.
And it's interesting too, though, because there's the auction process now as well. And so one thing that has helped curb some of the squatters, or the people who, just go in and try to steal identity and then ransom back the domain to you, was that implementation of the auto renewal and the auction procedure.
Right. Yeah, no, I guess the last thing before we're almost out of time here, but is, so in this bad faith context, most people don't realize this, but the fact that somebody comes to you and tries to sell you your trademark, if they don't have rights in it, like, so we're not talking about the Nissan guy. This is just somebody registers your trademark.shop and then comes and tries to sell it to you. If they're trying to sell it to you for more than their actual costs and what they registered it, that itself is evidence of bad faith. And that a lot of times carries the day on these
Yeah.
disputes. Is that, they reach out to you and you're like, yeah, sure. We'll give you, $200 for your trouble, and, your registrations and all this kind of, all of your fees and that kind of thing. And they come back and say, nah, we were thinking more like 20,000. that is evidence of bad faith because they don't have rights in it. The only reason that they've registered it is to try to make a, get a payday from you.
That's right. And now you go ahead, you file your UDRP complaint and you get the transfer for free. I mean, you're out of pocket your cost to WIPO, which I think is around $1,500, and whatever you pay your attorneys. But at the end of the day, the bad guy gets nothing. So
Yes. So
anyhow.
well, it was fun talking to you, Sharon.
It was always fun, Justin. And if anyone has any questions, feel free to reach out to either one of us. Thank you.
Thank you.